Okay, it's right around 6:31, and I'm going to get started. Um, and I'm going to go ahead and go over the details of this week's assignment. Okay. The first thing I just want to say, though, is the job fair is tonight at 6 o'clock, so I guess it's already started. So sometimes people should be still made aware of this, but it's going to start at 6, and so I guess it's kind of late to register for it and everything, so I'm going to skip over that. And I'm going to go right to our announcements for the week. The exclusionary rule of evidence. Reading chapter 6 of criminal evidence, and completing the activity is the evidence admissible in court. And finally, you have two things. You have the exclusionary rule of evidence. Is it really effective? And that's in a discussion post. Remember your initial post, which was submitted on Tuesday, so I already saw that. And your reply post by Saturday, I will submit a post for you to reply to on Friday, and you'll have that. And then finally, the written assignment, chart the rule. So you're going to make sure you follow that. We're going to discuss that a little more in detail. Continue to research on your criminal evidence project. Remember, you'll need information for future assignments. And then don't worry about the mid-quarter student survey because it's just us in here. So as a result, you don't have to do that because it's anonymous. And if you did the survey, I'll know who did it. So don't worry about it. Unless you do want to just make some remarks, that's fine. Or you want to complete it, that's up to you. But I'll know exactly who it is. So, of course, whatever remarks, I won't hold them against you. You already know that, though. You've had me in other classes. So, and then adversity is a springboard to success. I think you already know about that as well from other classes I've taught. So let's get through and let's look at the course calendar quickly. Again, sets out what the assignments are for this week. And you can see your reading assignment, and then your initial post, the lecture tonight, then your reply post, which will be due on Saturday by 11:59 p.m. Central Standard Time. Excuse me. And then the assignments that I will discuss in a minute. And then I remind you about your course project. Remember, it's not an assignment that's due yet. Okay. So now let's get to week 4. See the actual assignments again. Okay, now chart the rule, and the scenario is given to you saying that you're a chief and you're going to be the one providing training. Create a chart or grid outlining some of the points regarding the exclusionary rule of evidence, and be sure this rule has an impact on law enforcement and criminal trials. So what you're going to do is what you've learned already from your reading and everything concerning the exclusionary rule. You're going to develop a chart for your parties that you're over. In other words, the officers and police that are involved, because you're put in a position as department chief. Remember, that is due on Sunday, by 11:59 p.m. Central Standard Time. And so you want to make sure that you submit it the way that you normally do as a Word document. And then, of course, your discussion post, okay? Those are the two assignments. So it's not really that heavy for the week. You're focusing on the exclusionary rule, okay? So now let's get back and take a look at what the lesson content is, which is also very brief. So we're dealing with the exclusionary rule. That's the topic for the whole week. Reading, and then is the evidence admissible in court? We're going to talk about that. Chart the rule. We've already gone over that. Your discussion post, and then the reminder to continue to research and prepare for your criminal evidence project. So here we go. This will help you with your chart, actually. And the exclusionary rule, which, you know, as a defense attorney, I stated this in the response to your post, that the exclusionary rule is a friend of the defense attorney, and that it actually forces law enforcement to obey the rules as set out in the U.S. Constitution and cases at the United States Supreme Court. So it says here the admissibility of evidence is perhaps the most single important part of a trial, of course, because all evidence is what determines whether a person is guilty or not. And what is admitted, what the judge allows into evidence, could determine the facts. And so the exclusionary rule came out in People versus U.S. and Weeks versus U.S., where the court ruled that anything with a few exceptions, and we're going to talk about those, illegally obtained cannot be used at trial. Again, and the reason for that is because of the fact that it violates our constitutional rights to the Fourth Amendment, unreasonable searches and seizures. So let's spend some time going over this. Okay. So let's see, the exclusionary rule of evidence. So tells you to roll over the images below for more information on each of the 6 exceptions. So there are only 6 exceptions. Standing has nothing to do with a physical thing. It just basically says that you have to have the right. You have to be the right person to object to the evidence. In other words, the only one who can really deal with this is that if the police violate the rights of someone other than the defendant, that person doesn't have the right to object to it. So the defendant, why? Well, the only one who's in jeopardy is a defendant. So that is one of the exceptions, which no really person has any real trouble with. It made sense. A case that came out in 1978, right after I came out of law school. I remember that case pretty well, and you know, it made a whole lot of sense. I think, if I recall correctly, it was a family member of someone trying to object. But anyway, the bottom line was it has to be the defendant. That's what we mean by standing. You have to be in the shoes of the person who would receive jeopardy. Okay. So now let's look at it. So evidence seized under the authority of a search warrant that is later challenged to be invalid can still be admitted if the reasonable agent has acted in good faith relying on the search warrant. So let's say the search warrant turns out to be defective for some form or another, but that the officer operated in good faith in carrying out his or her responsibilities in conducting the search. In that instance, the court says, well, the officer was not aware that the warrant was not any good, and that because it could be challenged later. What happens is that the search would take place, and then a motion to suppress might include an allegation that the warrant that was issued was not issued on probable cause, and therefore, as a result, appealing it to a higher court might say, if they say yes, then the attorney might come back and say, well, okay, in that case, the evidence that was obtained could not be used. So the courts came along in 1984 and taking the side of the prosecution, saying, well, if the officer acted in good faith, then they shouldn't be penalized, and that the prosecution shouldn't be penalized from bringing in this evidence because of that fact. So, I mean, as a defense attorney, it's our position generally that, well, if you violate the rule, you violate the rule. So they said, yeah, but now there is an exception. So here's what I'm telling you, is that the case of Weeks said what it said, and now what we're doing is cutting into it with the standing issue and with the good faith issue. So basically, that's what it is. It's kind of like the same kind of thing that you've learned, and I think we talked about this before, that with the hearsay evidence, that hearsay evidence is not admissible. However, the federal rules of evidence, and many states, as I said, have adopted those rules in the jurisdictions that says that these exceptions make sense and would be an unfair weight around prosecution in terms of presenting evidence or someone presenting evidence. Same kind of thing is applying here, saying that then it would be unreasonable to apply the exclusionary rule in these instances, okay? Now, I don't know what the vote was on here, but I can tell you that, you know, if it's 5-4, it could change with 1. But I can tell you that the direction that the courts are going in now is to favor law enforcement. So there's a good chance that most of these cases, like Rekas and Leon, would not be overturned by our president or in the very near future Supreme Court. Okay, let's talk about attenuated, which means it's weakened. Let's say it says from the illegal conduct of police. So if the evidence is not obtained directly as a result, not directly, it could be indirectly as a result of police misconduct, then in that instance, it would be admitted into court. Now, the Wong Sun case, a 1963 case, I remember we went over this in my criminal law class, and it was a case that basically took the position that the police themselves might have been technically illegal, but it wasn't directly. The evidence that was recovered, I can't remember what it was recovered not because of their illegal conduct, but it could have been discovered by some other basis. And so as a result, then another exception was extended into the court. Now, it started to sound like, well, wait a minute, we're really not, we're erasing it gradually. Yes and no, but it's an attempt to, as many judges might say, or many legal scholars might say, to level the playing field, so to speak, and not to give the bigger end to the individuals who were defendants in the case. So So the point of the matter is that in this case, Wong San, it kind of lays it out. It says basically, just a summary of this case, it says that it excludes the presentation of verbal evidence and evidence and recovered narcotics both were fruits of an illegal entry. So when the agents arrested Wong Song, all were arraigned and released on their recognizance. However, though, the Supreme Court decided in this particular case, that, and I'm going to give you a little more. It says the narcotics, it's all about drugs, and so it says that narcotics agents unlawfully entered the laundry of Toy's laundry, at which point Toy indicated that Johnny was selling narcotics. The drug agents then went to Johnny and found narcotics. Johnny made a deal to give up his supplier, Wong Sun. The agents then arrested Wong Sun, and all were arraigned and released. Several days later, Wong Sun voluntarily returned to the police to make a statement, during the process of which he confessed. So the holding and decision in this case was that the presentation of the verbal evidence and recovered narcotics, where they were both fruits of an illegal entry, are inadmissible in court, except where there is a break in the chain of evidence, and there was a break in the chain of evidence. So, and further, Wong Song's lawyer argued that Wong Song's confession should not be excluded as fruit of the poisonous tree. When we say fruit of the poisonous tree, we're talking about of an illegal search or something like that. That's a doctrine. But Wong Song's statement was ruled admissible. His statement was admissible because he had no standing to suppress the evidence found in Johnny's apartment, because he wasn't the one who had the drugs. Wong Song was granted a new trial, but his confession was still admissible. So it made it. That's the attenuation rule that came about. Let's go to the next one. The evidence obtained during an illegal search will not be suppressed by the court if the same evidence can be located through an independent source. So in other words, if there's a source other than that individual, that evidence could still be used in a case against an individual. And I don't have the case in front of me, but at any rate, it's a well-established independent source exception that if the evidence could be located through another way, let's say, for example, through them plain viewing, seeing it in themselves, those kind of things, that would be an independent source. And so it would not be an illegal search in a situation like that, okay? Same thing here with inevitable discovery. Evidence that can be established through another method or by the court if the government can establish that the evidence would have been discovered. Let's say, for example, it was on the ground someplace and the person threw it and they discovered it that way. The point of the matter is that what is happening here is that in these instances, the police themselves or law enforcement are not really doing anything other than doing what they're supposed to be doing, and they can inadvertently come upon something, and then in that case, they don't have to ignore it and then get a warrant. Because why? Because an exigent circumstances exist and it can disappear. So anyway, so the law with this exception, makes a whole lot of sense, and it's common sense, that if the evidence would have been inevitably discovered by means other than that, and that's the burden on the prosecution to present that type of statement to justify the evidence that's seized or recovered. And finally, illegally seized evidence may be admitted in court in certain circumstances if it's considered important enough to uncover the truth of something. Examples are like in grand jury hearings. It's an investigatory tool. It's not to determine the innocence or guilt of a person. Sentencing, once again, jeopardy is already set in, and so now the evidence is being used to determine the sentence of an individual as opposed to whether or not they committed the offense or not. Probation, revocation hearings, as you should know already, those hearings are based upon preponderance of the evidence and not reasonable doubt. So in probation, revocation hearings, that kind of evidence is also allowed. You should also be aware of the fact that if it's a parole hearing, that also the same thing applies as well as certain civil hearings. Once again, we're not dealing with the beyond a reasonable doubt determination. We're dealing with the preponderance of the evidence. So, okay. We're going to go into the next one. Okay, and this says read the case and click on which exception fits. So let's see how well we do. Pamela Powers, who's 10, was murdered by Robert Williams, a mental patient. During the bus ride to the prison, Williams confessed to the crime and directed the officers to the body. In the trial, the defense argued that the body should not be used as evidence since Williams' confession was obtained illegally. The court later ruled that the body could be admitted as evidence because the state would have eventually found it legally. So how about this is it? Yep. I mean, it kind of gives it away. Inevitable discovery, because the body, now you begin to see how the rules actually apply and make sense in a real life scenario. So it's possible that the body could have been inevitably discovered later, and the statement that he made was not did not disqualify it as a basis in the statement because he was mentally a patient. Meant that the body would have been eventually discovered at some point anyway, okay? Federal narcotics agents arrest the subject for possession of heroin and don't have an arrest warrant. Suspect was arraigned and released. Later, he voluntarily made a statement admitting he had heroin. Voluntary statement that he had heroin. The court ruled that the arrest was unlawful, thereby weakening all evidence. Still, the statement was obtained legally and could be admitted as evidence. Attenuation, just like what I had talked about to you earlier. Makes sense because the court ruled that the arrest was unlawful. Weakening all evidence, yet still the statement was legally obtained, okay, because he voluntarily made the statement, all right. And that's the end of that one. I wish they'd had more of these because these were really, I liked what they did in these. I just wish they'd had more examples here. So what's the general rule? Collect evidence carefully. That's what I tell all my law enforcement students in another class that I teach. Because the exclusionary rule, it is absolutely critical for police to understand the proper procedures for gathering criminal evidence and to follow it at all times. And then says additionally, through knowledge of the exclusionary rule itself, with knowing then it does and does not apply, such as exigent circumstances, which I said earlier about that, will allow police professionals to do their part in ensuring all evidence will be considered admissible. So the key thing is trying to make sure that you have good evidence that is admissible in court and that would probably stand the muster of an appeal based on the current law. That's the key thing. And so officers are trained constantly as the law changes. And that's it for the exclusionary rule. That's it for today. I'm going to stop sharing. Our next lecture will take place 2 weeks from today. And if you have any questions, feel free to reach out to me. I'm going to say good night.